I'm Ken Carlson. I have been an attorney helping tenants since 1980. I operate the caltenantlaw.com website where you will find this and other helpful videos on your rights as a tenant. In this video, we're going into extreme detail on just the motion to quash phase of the game board. This simple game phase is amazingly complicated as you outmaneuver your landlord one step at a time. If staying in possession for as long as possible is important to you, you will get a kick out of how the motion to quash phase works. In one case, it took a year. Seriously. It's your first move in the game. The concept of a motion to quash may sound silly at first. If you aren't given the eviction papers properly, you can prevent the case from going any further. Imagine if the landlord could get a judgment against you and evict you without your having a chance to defend yourself. The Constitution requires due process of law, including notice and an opportunity to be heard. That concept is applied by special laws that require the eviction papers to be served on you in specified ways, which are strictly enforced. Imagine a copy taped to your door on a windy day, but the wind blows it into the neighbor's yard. Did you get served? Nope. The goal is to make sure that you not only get the papers, but in the way that the legislature required you to get them. After filing the unlawful detainer, which we shorten to UD, the landlord has to serve the summons and complaint on you. The summons is the form stamped by the court clerk with the case number on it, warning you to defend yourself. The complaint is the landlord's accusations as to why the judge should evict you, also having the case number on it. There are usually other papers attached to it, like a prejudgment claim form. I will refer to this collection of papers as the UD packet. Because of all the abuses by process servers in eviction cases, a special law requires the court clerk to mail you a notice of filing to the physical address where you live, arriving a couple of days after the UD was filed. And it tells you that you need to file a response within the deadline to avoid losing. You can bring that notice to the courthouse, show it to the clerk, and ask for a copy of the complaint to give you a head start on your defense. There is a minor charge for the copies. If the process server hasn't come around yet, this is your warning that he will. If he already came before the court mail arrives, it's just old news. Getting a copy in this way is not service. The landlord can't serve the UD packet himself, like he can the eviction notice. It has to be done by someone else, any adult. Sometimes it's the sheriff, but usually a process server. A process server has to do the process correctly, but they typically lie under penalty of perjury, and the judges go along with it. To properly serve you, the process server may need to try 6 times, but they get the same amount of money for doing a sloppy and illegal service and falsely claiming that they personally served you. There are 3 kinds of service of the UD packet you may see. The first is personal service, like the process server handing the UD packet to you. The second is called substitute service, like leaving a copy with someone else and mailing a second copy to you. The third kind is called post and mail service, which is posting a copy on the door and mailing a copy to you by certified mail. The time you have to file your motion to quash starts from when and how the UD packet is given to you. Personal service requires actual contact with you. You don't have to sign for receiving the UD packet. Voice or eye contact is enough, and the process server can leave it in front of you or on the front door. A knock at the door by the process server, answered by talking through the door, identifying yourself as the named defendant, is enough. Eye contact through the window while the process server is identifying the papers he has for you can be enough. If you don't acknowledge the process server, then it's not personal service, even if he sees or hears you. If there's more than one of you, and only one of you is personally served, that doesn't count for the others. The clock starts for only that one. Dishonest process servers will often pretend to talk with the tenant through the door, either imagining the tenant talking, or hearing a radio or TV left on, or just seeing the car in the driveway. They say things like, "I know you're in there," or claiming that they saw someone inside when it never happened. In one case, my client had his passport stamped in Bombay, India, on the same day that the process server claimed to have personally served my client at home. When I brought it to the judge's attention, he just laughed it off and said, "Oh, must have been a case of mistaken identity." He should have had the process server arrested for perjury and put in prison, but it was a landlord's process server. Substitute service can only be done by first trying to personally serve the tenant, and then by leaving extra copies with one person and mailing a copy to the other person or people who are not there. For example, the wife is at home while the husband is away at work. The process server hands a copy to the wife and asks if the husband is present. She says no, so he gives her a second copy for her husband and mails a third copy to him by regular mail. That is correctly done. However, if there's no attempt to personally serve the husband in our example, it's no good. Just knocking on the door and handing the wife 2 copies with a "here you go" or "you're served" is not enough. Leaving only 1 copy with the wife is not enough, because that is for her, with no second copy for her husband. Forgetting to mail the 3rd copy to the husband is also a fatal mistake, because that is the second required part of substituted service. A copy can be left with someone who is not named as a defendant. It can be any person of, quote, "suitable age and discretion," close quote, which probably includes a subtenant, teenager, babysitter, guest, house sitter, or gardener, but not a small child or preteen, a drunk, an insane person, or the apartment manager. In very rare cases, it can be posted on the door, handed to anyone, and mailed. Obviously, there's a lot of gray area there, but that's all the more confusion for you to challenge by your motion to quash. The third type of service is the UD packet by posting and mailing under a judge's permission. To get this, the process server has to try personal or substitute service about 5 to 6 times on different days and different times of the day or night, and found nobody home or answering the door. Usually, they lie about making those attempts. The process server fills out a declaration with the dates and times of the claimed attempts, which is submitted to the judge by the landlord's lawyer, and the judge approves the service of process by posting and mailing. You can get a copy of the post and mail papers from the court clerk. When that is ordered, the process server can post a copy on the front door, or somewhere else obvious by a tape or thumbtack, and mail a second copy to the named defendant by certified mail to that address. The clock starts when they complete the last of that, either posting or mailing. It sounds easy enough, but once again, the landlords cut corners. Most commonly, the process server lies about making all those efforts to personally serve. They figure that since no one was there to challenge it, they might as well lie. Of course, if you were there near the front door and nobody knocked, you can catch them in that lie, and the post and mail order then becomes improper, as with the service done by that order. The process server may not mail it at all, or use regular mail rather than certified mail. Certified mail has the green sticker with the 20 numbers on it that you can check with USPS tracking to see if and when it was mailed. They may also send it by certified mail, but return receipt requested so that you have to sign for it, knowing that you're at work when the mail comes, so you wouldn't get it. Yet another trick is that if you live in a rural area and don't have mail delivery to your home, but only a P.O. box, they have the certified mail delivered to your home, causing it to be rejected, lost, or delayed. Do check your mail for the tan slip that the mail carrier is supposed to leave you to pick it up. These are the ways that you have to be served if you are named as a defendant in the UD. If the process server screwed up or cut corners, that is what gives you the right to file a motion to quash. A prejudgment claim. What if you live there but you aren't named as a defendant? None of your business? You have a choice. If you do nothing and the plaintiff wins the case, you can be evicted by the sheriff and you won't owe any money or have a judgment recorded against you that affects your credit and future chance of renting. If you do want to fight the eviction, you have to add yourself to the case as a defendant using a form called the Prejudgment Claim of Right to Possession I mentioned earlier. It is usually served as part of the UD packet, but you can also get a form from the Cal Tenant Law website or the courthouse. It is a kind of speak now or forever hold your peace thing. You have 10 calendar days from the date of service of the UD packet within which to file your prejudgment claim. That is less time than the named defendant has to file their motion to quash. The form is simple enough, asking your name, the eviction address, your mailing address, and what your relationship is to the property, like a sublease. The prejudgment claim has to be properly served on you, which requires 3 types of service: posting a copy on the door, mailing a copy to all occupants of your unit, and handing a copy to someone. Unlike the other 2 types of service, the prejudgment claim has to be done by a sheriff or registered process server. If it is not done, or not done correctly, your 10-day deadline to file the claim does not begin to run. In our earlier example, the process server might forget to hand a 3rd copy of the UD packet to the wife, or forget to post a copy outside the door, or forget to mail another copy to all occupants. If the process server was unregistered, that service is invalid, even if correctly done. If the prejudgment claim and UD packet are not properly served, the process server may still lie on the proof of service and claim that he did all 3 things. For example, it's common for the process server to do a post and mail service on the named defendants on grounds that no one was there, but also file a prejudgment claim proof of service that claims that he did serve someone with a copy. Which is it? Therefore, it's best for you to file your prejudgment claim as though you were properly served to prevent a default from being filed against you and being unable to defend based upon that lie. Then, having done that, you also file a motion to quash that improper service at the same time as the prejudgment claim provides. There's an exception to this strategy when it comes to a foreclosure eviction. If you are the tenant of a foreclosed landlord, you have special rights. They include the right to challenge an eviction after a judgment was entered against your landlord when the sheriff is about to lock you out. This right exists in a foreclosure eviction where you were not named as a defendant. In that situation, you don't have to file the prejudgment claim at the beginning. As a practical matter, you may not even know about the eviction until the sheriff's notice to vacate is posted. Under this exception, the sheriff would serve the notice to vacate, a copy of the writ of possession, and a third paper called a claim of right to possession. This claim, also called an Arietta claim, gives you the right to make the case start all over again as to you. The landlord may not have cared to fight the eviction because he doesn't live there and has washed his hands of it. He let the judgment happen because it didn't affect him, but it does you because this is your home. His failure to pay the mortgage from your rent payments is not your fault, so you get this break. You fill out the Arietta claim, make 2 more copies, and bring it to the sheriff's office that issued it. You show your ID proving that you live there, preferably a driver's license, and they stop the eviction, stamp the 2 copies, and you take those copies to the courthouse. The clerk set up at the Arietta hearing, and the judge looks at the evidence and, based upon the evidence, should allow you to start defending your interests. The same procedure is available to you if the landlord did not properly serve the prejudgment claim or did not file a proof of service and default against unnamed occupants. In that case, the sheriff also includes the Arietta claim with the notice to vacate packet. You fill it out and file it with the sheriff and the court clerks in the same way with the same Arietta hearing. However, some judges find an excuse not to give you that chance, feeling sorry for the poor landlord, and deny your claim. That is why it's better not to risk that situation if you can, and file the prejudgment claim at the beginning. These are all the kinds of service of the UD packet that have to occur. You needed to know that so you understand when, how, and why we challenge the landlord through the motion to quash itself. The deadlines. As the summons said, you have 10 court days to file your response. If you miss the deadline, you could lose by default and end up being evicted without a trial. You can undo that default and unlose, but it's not guaranteed, and if you have a judge that is only there for the landlords, as too many are, that may be the case. The deadlines are tricky to calculate depending on circumstances, not like a flat X days no matter what. A court day is like a business day, so Monday through Friday and excluding court holidays. In most cases, that's 2 calendar weeks. A court holiday may not match with national holidays, so you need to check. The day of service is day 0 of the 10 days. If the last day falls on a weekend or holiday, the deadline is the next court day. For example, if that last day is Thanksgiving, the real deadline is postponed until the following Monday. For personal service of the UD packet, the deadline is 10 court days after that. For substituted service, the mailing adds 5 more days from the date of mailing. The postmark could be the day after that mailing. In the husband and wife example earlier, if his summons and complaint was mailed on the same day as she was personally served, her deadline would be 2 weeks later, and his would be 2 weeks plus 5 calendar days for the mailing. If his copy was mailed 3 days after she was served, he would have 2 weeks plus 8 days for the delayed mailing. For the post and mail service, you have 10 calendar days from completion, of both the posting and mailing as the starting point, plus the 10 court days, at least 2 weeks, within which to file your motion to quash. For example, if the posting and certified mailing were completed on the 1st of the month, the service is defined as being done on the 11th of the month, leaving you 2 more weeks by the summons to the 25th of the month as your earliest deadline. If that last day is a weekend, then you have even more time to the next court day. It's almost a month. For the prejudgment claim, the deadline to file it is 10 calendar days from the date that the process server puts on the form, despite its service is by posting and mailing. If no date of service is on a blank prejudgment claim form you receive, the process server could claim any date. To be extra cautious and avoid a default, you should file the prejudgment claim as early as possible, starting 10 days after the case was filed. You could not have been served before the case was filed, but the process server could falsely claim that he served the prejudgment UD packet on you on that same day that he filed the case. By the way, even if you miss the deadline, you can still file your papers unless the landlord has filed for your default and the clerk has entered default. Typically, the landlord's lawyers file a request for default and a request for trial on the same day after your deadline, where either you didn't answer or you filed an answer and the case can be set for trial. However, in their haste to take your default, the landlord's lawyer may have made a mistake in the default request or failed to include a proper proof of service. In that case, even though they requested your default is not entered, and you can still file your motion to quash after the deadline until they correct the mistake and refile. If by the time they refile their request for default, your motion to quash is filed, their default request is rejected because you did file that response. What you learn from this is that if you know the UD is filed, don't answer the door or talk through the door, keep the blinds drawn, and make yourself scarce for a few days. If someone comes to the door unannounced, guess who? You are under no legal duty to answer the door or accept service. If you don't make it easy for the process server, you could end up postponing your deadline to file your first papers for over a month. That's just the first phase of this case before you even file your papers. As your first psychological blow to your smug and arrogant landlord, the motion to quash shocks him. His lawyer didn't tell him about it, but promised you'd be out in a matter of a few weeks. The lawyer has to tell your landlord about a change of plans. If you file a motion to quash, it's a red flag. You are going to be one tough tenant to evict. It's going to be much longer and more expensive than the lawyer had promised, and if there are any cracks in the case, the landlord could lose badly. The motion to quash is drafted by your lawyer. Don't try to do it yourself or use AI because it won't come out correctly. This is not the time to be penny wise and pound foolish. Do it right and get the maximum effect. You could end up winning this case or winning this phase again and again. In one case, I did 7 full loops. The motion is set for hearing by the court clerk, who reserves the date, time, and place, or your court may let you set it yourself. The motion to quash is supposed to be heard 3 to 7 days after filing, but in most courts they have so many cases that it may have to be set out a few weeks later. That date is placed on the front page of your motion. The motion also includes a memorandum of points and authorities, which explains why the motion should be granted, and your declaration, which described what really happened. You might also have some evidence to share, like a security camera picture of the process server, or your work time card showing that you weren't at home at the time he claims personal service. There may be more than one reason for the motion to quash because process servers are sloppy. The landlord's lawyer may file the proof of service before you file your motion to quash, but usually they do it right before the motion to quash hearing. From the things I discussed earlier, you can see what mistakes and/or dishonesty support your motion. This is what they were supposed to do, but that is what they did. The motion papers are filed with the court clerk and sent to the landlord's lawyer. There is what is called a first appearance fee of between $225 and $435 per defendant, depending on the amount that the landlord is suing for in the complaint. That needs to be paid when you file a response. There is also a motion fee of about $60 for the motion to quash. California counties vary on what they charge on filing a motion to quash. Some only require the $60 motion fee, and you don't pay the first appearance fee until your next filing. Other courthouses require you to pay the first appearance fee with the motion to quash and interpret it as also covering the motion fee. Still other counties charge both the first appearance fee and the motion fee. For a lot of you, that is unaffordable, but that's because you qualify for a fee waiver. Each defendant who qualifies for the fee waiver fills out this form and submits it with the motion to quash. If you're getting some form of government assistance like Medi-Cal or food stamps, you automatically qualify. If your household income is below the listed amounts, you also qualify. If you don't qualify under either of those, you can still qualify because you have a lot of expenses. So when in doubt, fill it out. If it's denied, you can request a hearing, or even take that dispute up to the appeals court. Even if you were physically served correctly, such as by personal service, you may and often are able to file what is called a Delta motion to quash. It came from a case called Delta Imports, which allowed the motion to quash to be served if what is described in the complaint has certain defects. The idea is that the special kind of summons reserved only for UDs can't be used to bring you under the court's authority unless it is a real UD. If the complaint doesn't state a cause of action for unlawful detainer, the normal 30-day notice for other kinds of cases should have been used instead of the 2-week notice permitted just for evicting tenants. For example, a personal injury case requires a 30-day summons. The Delta motion looks at very technical things that are mistakes in the complaint which fail to say what is required in an eviction case. For example, if the wrong eviction notice was given, or is not described as being correctly served, and many other ways, the Delta motion can be used by you. You could win the whole case on that basis, but the judges usually refuse to see your point and deny it. If they do, you can raise those same points again in your demurrer to the complaint, which I'll discuss in another video. The important thing is that you know that you can file a motion to quash even if the service of summons is otherwise correct. There are two important aspects to the motion that we include. The first is that you say you are submitting on the papers. This means that you will not be attending, but they must count you as being there, letting the paperwork speak for you. As a practical matter, you wouldn't know what to say anyway, so the paperwork really does speak for you. As a tactical matter, you don't show up for the hearing because, if you did, they would just serve you right there in person, and your deadline to file your next papers would start from then. Why make it easy for them? You could win the motion, but if you showed up and were served right there, you lose the motion because it doesn't matter anymore. The other aspect of the case is that you want a fair judge to hear your motion, not a strongly pro-landlord judge who won't even read your papers, as is often the case. You can have some control over who will hear your motion and the rest of your case. There are judges who are appointed by the governor, but then there are commissioners who are hired by the courthouse, and judge pro tems, who are local lawyers volunteering to play judge for the day. You have the constitutional right to have a judge hear your case, so you can say in your motion that you do not stipulate to a commissioner or judge pro tem. You also have the right to reject one judge, called a peremptory challenge, for no more than you think that you would not have a fair trial with them. You don't need to prove anything. It's automatic. The reason why you would use these is to get away from a pro-landlord judge in order to hopefully have one who is fair and actually follows the law. The landlord's lawyer can file an opposition to your motion, but they usually don't. It would say why they think your motion should be denied. It would have its own memorandum and may have a declaration by the process server saying what he claims happened and the proofs of service and of the summons and complaint that he prepared and other evidence. It has to be served on you by the day before the motion to quash hearing so you can respond. If there is time, you can file what is called a reply, which is your written reaction to their opposition, such as to point out discrepancies or find legal points. Your lawyer would also write that for you. At the time announced in the motion, the hearing on the motion to quash will begin. The first step may be to reassign the case to a judge due to your rejection of a commissioner or judge pro tem, or to reassign the hearing to a different judge if you've made a peremptory challenge to the one who normally hears eviction cases. That might involve a continuance of the hearing to another day, or even transferring it to a different courthouse. Nowadays, most hearings can be watched online, with hardly anyone in the actual courtroom. The judge is supposed to read the papers, yours and the opposition, listen to testimony and debate by the lawyers, and then decide the motion based upon the facts and evidence. Unfortunately, that hardly ever occurs. Since you are not there, the judge may just deny the motion because you are not there. If it's a commissioner or judge pro tem or the judge you rejected, they may not even read your motion and just deny it because you weren't there. The judge may even cancel the hearing because you're not there, called taking it off calendar. The landlord's lawyer whines that your motion is just a dilatory tactic, that the process server must be believed, and that the judge should order trial for the next available time. Usually, the judge just denies the motion without any law or evidence to support that decision, contrary to all of your law and evidence, and requires you to respond to the complaint. All of those things are wrong. If you had rejected the person making the ruling, but they ruled anyway, it's wrong even if they ruled correctly. You have the right to submit on the papers and not go to the hearing. If you aren't attending, that is not a ground to deny the motion, and taking the motion off calendar is incorrect, because the judge is required to treat you as though you were there. If there's no evidence challenging yours, you should win. If you challenge the service by a process server, the landlord has the burden to overcome that challenge with real proof, not just talk. Of course, the motion to quash does delay the trial, but if your motion has legal and factual basis, the delay is the landlord's fault, not yours. The judges just tend to believe the process servers. They are chummy with the landlord lawyers who frequently appear before them. Expect that your motion will be denied. Only about 10% of the motions to quash are granted. That's okay, because you already achieved a primary objective of getting more time, and because you now have the opportunity for even more delay and a reversal of the judge's ruling, and getting yet another different judge. In the judge's decision, you are to respond within 5 days of the notice of ruling. That's not 5 days from the court hearing or within 5 days of your learning about it. There is a notice of ruling on paper that has to be properly served on you. If the court clerk sends it, you usually get a copy of what is called the minute order of the hearing. That's a brief description of what happened at your motion to quash hearing and how the judge ruled. Usually, it's the landlord's attorney who mails you the notice of ruling. If that mailing is by overnight mail, you have 5 days plus 2 for the overnight mail. If it's by regular mail, you have 5 days plus the normal 5 days for mailing. If the notice is delivered to you, like posted on your door, you have 5 days after that. Unless and until you get the notice of ruling, the 5-day clock does not start. As I've mentioned earlier, because the landlord's lawyers and process servers are accustomed to lying and getting away with it, they may falsely claim that they sent you the notice when they never did, so that they can just take your default. Built into the law is a mini appeal called a petition for writ of mandate, where you point out the judge's mistakes and ask the appeals court to correct the trial court judge. All you're trying to do is get the courts to follow the law. Nothing outrageous. You need to file the petition within that 5-day plus deadline, or you can be defaulted. The petition stops the eviction in its place until the appeals court rules. There are 2 parts to the petition. The first part is your actual petition, where you identify the error by the trial court and include the papers that show the mistake. That is filed in the appeals court. Most evictions are in the limited division of the Superior Court, meaning less than $35,000 is at stake. In those cases, the petition is filed with the appellate department of the Superior Court. If it is an unlimited division case involving more than $35,000, then your petition would be filed in the District Court of Appeals, just one level under the California Supreme Court. There are filing fees for those petitions and the same fee waiver applications as you use in the trial court. The other part is a notice of filing that is filed with the trial court. That notice has a copy of the petition you're filing with the appeals court so that the trial court knows you are reviewing the motion to quash ruling with the appeals court. We also send a copy of those papers to the landlord's lawyer. By filing that notice of filing and serving the landlord's lawyer with a copy of it, your time to file your demurrer is postponed until 15 days after the Court of Appeals mails its denial of your petition. They might deny the petition right away, or they might take months to decide what to do about it. But if they agree with you, the appeals court may order the trial court judge to undo the ruling, change it in some way, transfer the case to a different judge, submit an explanation for the trial court's ruling, or have a hearing on whether it will accept the appeal court's evaluation. If the appeals court orders the trial judge to change something, you have the right to get rid of that judge who ruled against you and get another judge to continue with the case. By this time, you may be several months into the eviction and you're only halfway to trial. If you lose the writ of mandate petition, you at least have the extra time to file your demur, begin discovery, and continue to explore your options to move elsewhere. Looking back on what's happened, you realize that if the landlord had just done the service of the UD packet properly, he would have been to trial already. It never works that way. The arrogance of the landlord and his lawyer make them fight you at every step, even if it wastes time and money. It's your fault, they tell themselves, not theirs. If the appeal court agrees with you and the landlord has to start over with a new service of the UD packet, the new attempt may also be defective. If it is, you can file another motion to quash as to that. If the trial judge makes a new ruling that is also incorrect, you can file a new petition to challenge that mistake. It's a loop. As I said earlier, I have kept cases in this loop for up to a year, and in another case, 7 loops for almost a year. At some point, you stop the motion to quash phase of the game board and move on to the next. In most cases, you return to the case with discovery and file your demur to the complaint. There are special laws as to your next step if it's a foreclosure eviction and you are the tenant. You claim rights under the federal law called the Protecting Tenants at Foreclosure Act. That gives you the right to literally make a federal case out of the UD by filing what is called a notice of removal. That step can add from 1 to 3 months before you get around to filing your demur. Now, you ask what time it is, but I told you how the clock works. All you wanted to know was why you should file a motion to quash and how much time it would add up front in your case. But as you've just learned, the answer depends on many things. Since the landlord was expecting to have you out in a month, but he is only at first base after several months, you are winning in real terms. He is starting to get that sinking feeling that things might not go as he planned or as quickly. The discovery and demur videos are next in the series. I'll see you then.